Hi, this is Pat Iyer with Legal Nurse Podcast. Today we're going to talk about a very important method of resolving cases today, in particular with courtrooms closed and attorneys wanting pretty desperately to resolve their cases and unable to do so in a traditional trial setting. Jaimee Gerrie is a person who I've met through running my legal nurse consulting conference with Barbara Levin. She attended one of our sessions and has since joined our membership program, LNC Success Connection. Jaimee, welcome to the show.
Thank you, Pat. I'm so excited to be here and talk about this unique role as a legal nurse consultant today.
When Jaimee and I first talked, she was exploring the opportunities that are associated with being a mediator. She has 27 years of clinical professional nursing experience and faculty experience, and she specializes in dispute resolution. Jaimee works with attorneys and healthcare clients on medically related cases. So she's straddling the world of being a mediator and a legal nurse consultant. I know that some people who are listening to this podcast, Jaimee, will appreciate a definition. They've heard about mediation, they've heard about arbitration. Can we talk about what is mediation, what is arbitration, and how do these two work within the legal system?
Okay. Thank you, Pat. That's a great question. And I do receive that question often from people that I am communicating with. And it is something that we also resolve in our training as mediators. The mediation process is a structured process in which a trained individual, a trained mediator, it serves as a neutral third party like myself to assist people to receive or resolve conflict issues or to come to an agreement that each person can accept. So the idea behind mediation is that the neutral third party remains non-judgmental, is able to help facilitate active conversation and exploration of underlying issues to come to a resolution of a conflict. So I'm not there in that role to decide what things should be. I'm there to assist the parties in finding that resolution themselves, able to empower them to find that resolution themselves. And hopefully they walk away feeling much more satisfied. The goal is the win-win between them. In an arbitration, there is an arbitrator that has been clearly defined, has reviewed the case thoroughly, comes prepared to make a decision. So an arbitrator may run an arbitration very similar to a trial outside of the court where witnesses may present certain pieces of their case to that arbitrator. The arbitrator then takes everything under consideration and comes back with a decision to resolve that case. And that becomes a binding court agreement with those parties. So very different in the way things are approached. One avenue is a deciding individual. The other is one there to facilitate that process.
I know that we've heard the term binding arbitration, and it sounds to me that the arbitrator is acting much more like a judge in making a decision, whereas the mediator is a facilitator to help people walk away being happy with the resolution.
Yes, that is the ultimate goal. Happiness would be absolutely wonderful. Sometimes we can't achieve full happiness, but a win-win where both parties feel equally heard, equally contributing to that agreement made between them and finding a resolution that they can both live with.
Are there instances when two parties go to a mediation and they can't reach any agreement and they walk away with the issue unresolved?
Sure, absolutely. We do have that happen. Even the best mediators can't always come to help individuals find resolution. So the goal is to go as far as you possibly can. And if that were to occur, then, we come to that agreement that we just have to agree to disagree. The parties will then look for another way to settle that dispute dispute. And that is often through the courts, which is a more expensive process as well. So, the mediator is there to help them find some understanding in that, do what we can to help them come to that resolution without having to spend that kind of time and money in the court system. It's expensive for both the courts and the individuals. So we do our best, but even our best cannot always find a resolution.
And I know that our listener might be unaware of the expenses associated with taking a case to trial. Can you outline some of the fees that are associated with putting a case on in a courtroom?
Putting a case on in a courtroom, you have your court fees, attorney fees, any other fees for records that may need to be sought after. You may have other expert fees depending on what that case is. And that can get to be very expensive. The time just alone in preparation of that case that's going to go to trial as well. So you may have lost work, wages as a result. You may have personal time, vacation time that may be spent as well. So those are some of the hidden costs of having to go through that process.
I know that attorneys have talked about just the transcripts. If something has happened critical the day before and they want a transcript of that testimony, they have to go to a court reporter who very happily charges them massive overtime rates to do an expedited transcript for the following day. And that is a significant factor. Bringing in expert witnesses from other parts of the country. It would be nothing for a physician, for example, to charge a day of travel, a day in the courtroom, a day of travel back. Now with virtual trials, the expert is getting paid for the time sitting in front of the Zoom monitor as opposed to all of the traveling associated with it. So I don't know that we always appreciate how much it costs to put on a trial until attorneys outline some of those fees that are extraordinary.
As well as the amount of stress. When you go to trial, there's also a loss of control over the decision making. And so as an individual that is in the middle of a dispute, you may wish for one outcome and the trial decides a different outcome. Whereas in a mediation process or through alternative dispute resolution, you can participate in that decision making. It doesn't always mean you get 100% of what you want, but you can give and take what is most important to you and be a very active participant in that decision-making process. So there's more control. Individuals that participate in the mediation process have more empowerment to make those decisions for themselves and come to a resolution that works best for them. Whereas when you go to court, that is always an option, and understanding the expense of that, but you also lose the ability then to make those decisions for yourself.
Yeah, I've been in many courtrooms where I watched the way that the judge handles the trial. I have been able to tell when I walked in a room if the judge liked one of the attorneys, the defense or the plaintiff attorney, or strongly disliked one of the attorneys. The nonverbal body language, the size, the pauses, the rulings can betray an attitude towards one of the attorneys, perhaps based on past experience. There was one female judge in New Jersey that the attorneys would openly discuss that she had psychiatric problems. At least that was how they attributed her behavior. And, oh, she's not on her meds today, so we're going to have a hard time. So yes, that's another whole risk associated with trial is what is the personality of that judge? What is the mood of that judge? What is the skill level? Some states, and this caught me off guard the first time I heard it, they publish a list of how the judges are rated by the attorneys. And there's a number one judge and there's a number 432 judge, and this woman got known as the 432 judge in the ranking order of most desirable judges.
Mhm. That plays a important role into trials, absolutely. The mediator, which is in a little bit of contrast to playing favorites or having favorites, a mediator's role is to be non-judgmental. Mediator's role is to remain neutral, to not have opinions. So one of the things that was really emphasized in my training getting into mediation was that it's not always important to have every detail. The less you know actually can actually serve you better as a mediator. And so I've tried to play that to my skill set just a little bit, being able to work with individuals to get those individuals to tell their story so that I can learn about the case once I really get into mediation. So there's a process of intake that we go through to get a little bit going in. But what we want to do is assure that we're not establishing any bias during that process. And as humans, we know that bias does exist no matter what. So being in tune, self-reflective, and learning how to manage those little innate biases that may come to the table so that we're not playing favorites. The goal is that both parties have equal opportunity at that table. And so that's a little different. We don't always work with attorneys as mediators. Sometimes it's best not to have the attorneys there so that people can work through those issues in a very non-judgmental, non-biased, non-conflictual way to the best of our ability.
Sounds like a very different atmosphere than the courtroom from my exposure to the courtroom.
It is. It is.
Now tell me about, you're a nurse. How did this role appeal to you? What was the hook that brought you from a nursing background into the mediation world?
Well, Pat, this was a little bit of a surprise to me, actually. When I was growing up, my mother always told me you need to be an attorney because you like to problem solve, you like to argue points, you like to dig in and research. Well, I found that in my actual life path, being a nurse was exactly where I needed to be. So when I stumbled across this role, I came by it somewhat naturally based on my personality and my history of how I moved throughout my nursing career. I moved from bedside nursing into management. I participated in negotiations, arbitrations. That's where I began to even testify. I work as an expert as well in my role as an LNC, and I absolutely love that role, expert in standards of care. And I came by that actually through testifying as a nurse and participating as a nurse from the bedside in those roles. As a mediator, I actually began to talk with an individual in our community who identified my skill set as well in conflict, communication, training. I do leadership trainings for individuals, and she attended one of my trainings. And she said, oh my goodness, just your ability to communicate, your ability to manage conflict, your ability to educate. We really need you to do this. You need to sign up. You need to take this next step and go through the training. And so I thought, why not? I was looking for a place to volunteer where my skill sets were best applied. I've done volunteer work throughout my life, but if you're not really using your skill set, sometimes you're just going through the motions to do good for others. And I thought, where can my talents really be used? And once I got into this training, I thought, oh my goodness, I have the right fit. And so I got my start doing pro bono work with our Community Dispute Resolution Center. I'm still very active and I mediate every single week for them on different cases. And I absolutely love it. I have found that my skills in negotiation, being at the table to negotiate employee contracts as a faculty member. Some of my leadership positions have really served me well. as a nurse, we develop such an innate ability through our training to assess scenarios, situations, people. And in that assessment comes a very strong ability to actively listen and to apply that listening to a person's body language, how they're reacting, how they're responding. And so my nursing skills, not just my ability to communicate, my ability to educate, my ability to help manage conflict, negotiate, but also those nursing skills make this a really good fit for me, because the environment that we're mediating in needs to be a non-threatening environment. It needs to be one that is presented so that individuals can reach, in nursing terms, optimal health and wellness. In mediation terms, it would be an agreement or a settlement. Mm-hmm. And so we want them to feel like the environment is supportive, that they can trust. And then in that whole process, my job is not to create the decision. I'm not the decision maker, but I need to use all of those assessment skills, all of that evaluation that I'm taking in to help lead them down a path to success. I can give an example, if you would love an example of one. And actually, this is not a general civil example. So general civil mediation is typically where you have two parties that are coming together to resolve a conflict. It could be a divorce, it could be medical malpractice, personal injury, workman's compensation, it could be a debit creditor situation where parties need to come and resolve together. This particular situation, I also do in my mediation what we call restorative justice. And so this is an example, though, that gives a really good picture of utilizing those skills to get to common ground with an individual and get them to find resolution in the case. So restorative justice, like I said, is where our goal as a mediator in this situation. I'm mediating on behalf of the prosecuting attorney for the county. And so what the prosecuting attorney does is he doesn't attend to the mediation. He sends a list of basically demands that he wants to have mediated. And so my role is to work with the individual that's coming to the table to find common ground with those demands, as well as how they right their wrong. So those are, they're actually very simple cases typically, but this one that I was working with was not so simple. It was a very recent case. We do mediation through Zoom, so I'm very comfortable with that. It's a confidential process, so I'm set up for that as well. This individual, mediation is voluntary. That's important to note as well, because at any time somebody can walk out of a mediation, unless it's court ordered. They can walk out of that mediation. So this individual volunteered for this program. Was coming to the table very angry, didn't understand why he was there in the first place. Charges had been brought against him for a general misdemeanor, and very, very upset, very irate, demanded that somebody meet with him in person, could not do this over Zoom, refused absolutely to do it over Zoom. So I was willing. I had my vaccines and I was willing to go in and mediate this situation. Well, in that mediation, what I'm trying to get to with this story is that although he was really angry and belligerent, my job was to just sit back, remind him gently about the rules of mediation, that we're respectful. We don't blame and name call, no screaming. It should not be a threatening environment. So keeping my voice very calm, like I would with a patient at, the bedside, somebody that's very upset about a recent diagnosis or something that was going on. And I just started to listen. And by listening, I discovered that this individual, I don't even think to this day he knows that I figured it out. But just the process of watching his body language, how he was moving the papers about in front of him, his irritability, I discovered that he had a very hard time reading and writing, which made perfect sense why he didn't want to use Zoom. He probably could not easily. And so through just questions I would ask of this individual that led me down that path without actually having him to have to say to me, I can't read, I can't write very well. I just figured it out. So I altered the way I was approaching this individual to make sure that everything in front of him, I read to him. I just made sure that he was provided with everything. And then I just gently said, it is our normal process for me to read word for word for you. So if there's anything that you need to have reread, because sometimes when people are reading to us, we'll miss a word or something like that, please ask me to slow down and we'll go through it again, because the important thing here is that we're meeting halfway with the demands of the prosecutor and the issues you have and how you can work out this situation to restore your wrong. And by the time we were done, it was a longer mediation than normal in those cases. Like I said, those are very easy. They're typically one-on-one. And, but this took me about an hour and a half, where normally it's about 45 minutes. But he left satisfied. He was able to reach an agreement that he could live with, complete the responsibilities of that agreement to right his wrong. And we didn't have any further problems in that mediation process. He calmed right down. And I think it went very well. So, the skill set of, I know that's very basic for anyone that's listening to this, but the skill set doesn't change when you have multiple people in the room. And it's the ability to sit back and to listen, to let people tell their stories, to allow them to build trust with you, that you're not going to try to interject yourself into their decision-making, but rather to help them understand where it's coming from, why, what decisions they need to be made, and get to that resolution, really to find what it is that is most important to them in the process. And you do that mostly through active listening and then providing feedback and input along the way, but ultimately leading them to make that decision that this agreement is best for them.
I think you've given us a great example of how you use your nursing skills, which sets you apart from attorneys, judges, and business people who have gone through mediation training but don't have that healthcare background. Can you differentiate for us now? There are LNCs who will accompany patients to a mediation to help an attorney client. What is that role about?
That role is really a supportive role. So very much, I think, similar to working as an expert, you really do need to understand the case that you're involved in. You need to work very closely with the attorney. The attorney in that role is more of a negotiator, attempting to achieve settlement through the mediation process. So my role as an LNC is to make sure that I'm fully competent in the case, that I've attended to the details of that case, that I've helped that attorney process questions that need to be resolved in that process. During the mediation process, if exhibits are needed to help explain medical issues, reasons why whatever injury or damage that person received in this process requires a certain settlement amount. That's my job, is to help that attorney understand why it is that is needed. Also to sit and to listen actively. So I'm not mediating in that case. So I would not get involved in assuring that both sides are achieving equality per se, or actually win-win. My job is a support person for the attorney to do right by his client. And so my job is to watch the other side, to watch behaviors, to watch body language, to listen very intently, to take notes, to identify different things in that mediation process that are important for the attorney I'm working with or I'm hired to work with, to know as they're making their decisions and coming to an agreement.
I think that's an important distinction in terms of what you've laid out. As a mediator, you want both sides to be satisfied. As a person helping a plaintiff attorney, for example, you don't really care whether the defense attorney is happy with this resolution, as long as your client is able to achieve the maximum for the person that he or she is representing. And if you're on the defense side, you want to minimize what the insurance company is going to have to pay out for this injury. So you have a different objective.
Right.
Maximize for plaintiff, minimize for defense. It
Right.
sounds to me like the LNC could be quite helpful in providing some education for the people in the room about some of the medical issues that might be involved in a particular person's injury.
Oh, I agree with you. And, serving in that role for one attorney at that table doesn't mean that the education isn't needed for the opposite side as well. And so that's what makes us very unique, I think, as legal nurse consultants, is that we have that nursing background, the medical background, to be able to see the particular issues. The other thing that we are trained in, and those that do life care planning really understand this, is the foreseeability of what an injury may result in later down the road. And so having a nurse there to help identify some of those issues, I think, is very important. Very important. And in that role of educator, when we're at that table, again, we're not the negotiating party. So that isn't my role unless I'm asked to do that. So it is my role then is to provide that education as objectively as possible to help facilitate, finding that common ground or that settlement, so that the attorneys have the appropriate information about what is going on.
Can you mediate a case anywhere in the United States?
Well, that's a really good question, and I'm doing a little bit more learning on that. I would have to answer no. Every state has their requirements for mediators, but I certainly can mediate in many states. The requirement for mediation training is a 40-hour training requirement, and then it is accompanied by observation and performance of mediation. So as long as I am meeting the requirements, I also have an advanced degree. You do need to have an advanced degree. I hold a master's of science in nursing with an emphasis in leadership and management, which also contained conflict resolution skills and training. So I do have the education background as well as the training background to be able to serve as a mediator in many locations.
What would be the best way for our listener to be able to reach you if they had a question, or if they wanted to recommend to one of their clients that their client contact you to serve as a mediator?
I would love that opportunity. So you can reach me in a couple of different ways, directly by phone number that is also on my website, 906-322-0867. You can also reach me by email at Jaimee@Upvision Consulting LLC. And you can also reach me through my website, upvisionconsulting.com. So, and if you don't want to waste time with a simple phone call, you can also find on my website where you can just schedule a consultation call with me. So you have access right to my calendar. You get on there, I'm alerted, and you'll receive messages reminding you as well that our meeting is coming up. You can leave me a message in there so I can prepare a little bit for the conversation, and you can meet with me that way too.
And for the people who are listening to this program, can you repeat your phone number and then also spell out your first name, because it's got an extra little letter there?
It does. So my phone number, 906-322-0867. And the spelling of my first name is Jaimee.
And that goes with your email. Would you repeat your email address?
I will. It is Jaimee at Upvision, UPVISION consulting.com.
Perfect. Thank you, Jaimee. This has been very helpful and enlightening. I think that the information that you shared will expose to LNCs the concept of how mediation works, and they will see themselves as being potentially a part of this process to offer that medical support to their clients, as well as you might have sparked some curiosity in our listeners about exploring mediation as a supplement to an LNC role.
I think, Pat, I really want to thank you for the opportunity to be here and to talk about this role. As I'm exploring it as well, this is a really new role for legal nurse consultants. But if we look at what our skill set is all about, being able to work behind the scenes to help support attorneys, to be able to serve as experts, really it encompasses much of what we already do. It's just getting into a new venue. I can tell you that as a mediator, I have not once left, even in a difficult situation, a mediation that I didn't feel good about. It's a very rewarding opportunity, and so I would encourage others to check this out as an opportunity for their own business. And I'm absolutely happy to talk with anyone that would like to get started.
Perfect. Thank you, Jaimee. I appreciate that. And thank you to you who has been listening to this podcast on our audio channels or watching it on the Legal Nurse Business YouTube channel. Be sure to tell 2 or 3 other legal nurse consultants about Legal Nurse Podcast. We rely on you to spread the word through word of mouth and recommendations about our podcast. We have listeners now in 81 countries, and we are closing in on 100,000 downloads. The show has been in existence since September of 2016. And I love to be able to base shows on what is most important for you in your business. So please feel free to email me at patiyer@legalnursebusiness.com. That's Pat Iyer, Iyer, at legalnursebusiness.com. And tell me what you want to hear about. Thanks so much. Would you like the best of the best legal nurse consulting podcasts? Before I explain how you can get them, here's a tiny bit of background. I'm Pat Iyer. I started Legal Nurse Podcast in September 2016 to bring you tips, inspiration, and new ideas in a new format. I've written a lot of books, and I've taught a lot of courses, but I didn't have a way to reach you through audio. Since 2016, the podcast grew to include guest interviews, a co-host, transcripts, and the video format. When I started the podcast, what I did not expect was the extent of our international audience. My podcast hosting company keeps track of the location of our listeners and the number of downloads. You are part of an international audience. We have listeners in 82 countries. Our top 6 countries are the US, Japan, Canada, Australia, Germany, and the UK. Our podcasts have been downloaded over 102,000 times. And I know which shows are downloaded the most. That brings me to what I want to announce today. Now available is our newest podcast bundle of top shows. Using the data from our hosting company, I created bundles of top podcasts in 6 categories: marketing, client relationships, finance, business development, expertise, and stories of successful LNCs. These bundles are found only on my website at podcast.legalnursebusiness.com. Each bundle has the top 4 shows in that category. When you go to podcast.legalnursebusiness.com, you'll be able to put in your name and your email address and pick the category of bundle that you are interested in listening to. You'll pick that topic and you'll listen to the 4 shows in that bundle. You can pick one or more of the topics. You'll also be able to get the deluxe workbook, which has questions to deepen your knowledge and to help you focus on the key points in each of our shows. The workbook also has the full transcripts to enable you to refer to the knowledge we shared without having to re-listen to the show. There's a small investment for the workbook. Thank you for listening to Legal Nurse Podcast and watching it on our YouTube channel at Legal Nurse Business. Your interest keeps my podcast going and growing. And be sure to go to podcast.legalnursebusiness.com to pick your podcast bundles and workbooks to enhance your knowledge. This is Pat Iyer and Jaimee McCutcheon. We have just completed a podcast on some of the critical care liability issues and why the critical care environment is so high risk for the patients and also for the staff. Jaimee, what were some of the key points that we covered in your podcast?
Well, we discussed the atmosphere in the ICU. A lot of nurses are intimidated by the atmosphere, but we also talked about how laughter is really important medicine for the staff in the ICU. We talked about high-risk medications, liability issues with those types of medications. We talked about the camaraderie that when it goes awry in a unit like that, how it can affect the care that a patient gets. We also touched on charting and some of the common liability problems with the charting and some of the things that we chart quite often in the intensive care unit. And we also discussed, I forget, what else did we discuss, Pat? I'm sorry.
I think we ended up focusing on the challenges of working in the unit,
yes.
The atmosphere, the environment, the high intensity of technology in particular.
Right.
And I know
Yes.
that our viewer has heard about alarm fatigue, which is a huge issue in a critical care unit.
Yes, alarm fatigue is a big one. We did talk about that. Just the amount of alarms and the different sounds of all of the alarms that require your attention, but when you don't pay attention to them and how that can go wrong.
Or turn them off. We don't want to hear that
Or
anymore,
turn them
so
off.
let's just shut it off.
Or have a family member turn them off.
Aha.
Yeah.
Hadn't even thought about that.
Yeah.
Whoa, that could be a problem.
Family members can do all kinds of things when you're not in the room. So that's all another show.
You know, one of the funniest things that happened to me once when I was exhibiting at an attorney trial lawyers conference is that I had a big stuffed bear and I put a cervical collar on the bear and I put the bear in a patient gown and I had a bottle of D5W and a needle that was taped to the arm of the bear.
Right.
And I left this bear set up on my booth overnight. It was in a hotel in the Catskills in New York. And when I came in the next morning, the IV bag was dry. The bear's arm was dripping with saline. And I figured there must have been some curious person who came along and said, oh, I wonder what this roller clamp does. I wonder what this thing does. That was the end of my bear. My family member interfered with my bear's IV technology, low tech as it was.
I think that happens in all areas of nursing to some extent.
Luckily, it was just a stuffed bear. It wasn't anyone whose life was dependent upon what happens if you all of a sudden drop 500 cc's of D5W into somebody or with medications in it.
Right, exactly. Lucky bear.
Lucky bear, although it was the end of the bear's life. The bear ended up going into the trash after that exhibit. You can't really dry out a saturated bear with saline that's soaked into the stuffing of the arm. You'll hear more stories from Jaimee and from our podcast when you tune in to listen to Jaimee McCutcheon's show. You can catch it on our YouTube channel. Be sure to subscribe to our channel so that you get notified of new episodes. And you can also listen to it on all of our audio channels, Stitcher, iHeartRadio, Apple Podcasts, Spotify, and more. Thanks so much.